Hi guys, it's Kathy. I hope you're doing well. Well, everybody can thank Josh for today's stream. This doesn't happen often, but it happened yesterday. I got Colorado, the judge, I can't remember his name, but we watch him all of the time. 3 hours of him. I got Arapahoe. I got like 3 different districts in Colorado. Weld, Arapahoe, and one more it could even be Denver. I don't remember. I had all this content ready, and I'm going through it hour after hour after hour and found nothing. Absolutely nothing good or interesting. I could put it on for you. Not only that, there was like huge pauses in between people. Even in Colorado. I mean, even in Georgia, where he's like, let's go, I got another courtroom to go to. It was bad. So it's like 3 a.m. and I'm like, I don't know what I'm going to do. I was going to just play an old past stream or go to Sala. She's my go-to now. My go-to used to be O'Donnell because no one else covered O'Donnell. But now Minecraft Court is everywhere, so I don't go to him anymore. But Sala, I don't know why, she's gold and they don't cover her very often. And then I remembered Josh had sent me a link a couple days ago. He's like, hey, you're having a bad day or you're working a double. I can't remember exactly, but he's like, I know you're pressed for time right now. Here's a link if you need it. If you need content, here's a link. And then I turned it on. And that's why I'm so late, because I couldn't turn it off to start my stream at 4:30. So I suspect this might be a long stream. I suspect we might go over a little bit, because I couldn't stop. It's so good. It's really great. Josh, I know you're still asleep, but good job. Well done. This is awesome. Judge Dad. Yep, a YouTube judge. I'm allowed to do YouTube judges every once in a while.
All right, Julie Engel versus Bath for All LC DBA BFA LLC contractor and consultant. File number 2503653GC. Okay, gentlemen, your appearances, please.
Good morning, Your Honor. R. Thomas Badari on behalf of the plaintiff, Ms. Engel.
Good morning, Your Honor. Samuel Warren on behalf of Bath for All.
All right. And Ms. Engel, your name?
Julie Engel.
All right, good morning. So
Good morning.
this is your motion for summary disposition, Mr. Warren.
Yes, Your Honor. Defendant has moved for summary disposition under 3 different grounds, 2.116C8, 2.116C10, and 2.116C4. After reading plaintiff's response, it appears that plaintiff has abandoned counts 2 through 5, which resolves, assuming that is how we're proceeding, that resolves defendant's motion under 2.116C4 for lack of jurisdiction as to only 1 count. What remains before the court, assuming that is the course that plaintiff is taking, is a single count of breach of contract. The facts are not reasonably in dispute. There was a contract. The parties agreed to basically what happened. The question under C8 is the legal sufficiency of the complaint. I think of critical importance here is that in both the complaint and in plaintiff's response brief, plaintiff affixed an incomplete copy of the contract. It is missing page 5 of 6, and the sort of maxim of contract law in Michigan is to construe a contract as a whole. By
You didn't
not
draft it. You didn't draft that contract, did you, Mr. Warren?
I did not personally know, Your Honor. By not fixing a complete copy of the contract, it is impossible, so the legal sufficiency of the complaint, the court cannot interpret the contract as a whole with an incomplete contract. Additionally, according to plaintiff's own recitation of the facts, and her misinterpretation of the contract, she did not comply with the requirements under her own interpretation of the contract to get a refund of the deposit is labeled as non-refundable throughout the contract. Plaintiff developed an interpretation of the contract that would permit her to cancel at any time, assuming she gives notice twice within 3 days. According to plaintiff, she gave notice twice within
Callie.
4 days.
Thank you.
So defendant does not agree with plaintiff's construction of the contract. It's not what the contract as a whole says. But even if it did, she did not cancel the contract according to her own interpretation. As such, plaintiff, not defendant, is actually the breaching party. So under C8, again, according to the documents that plaintiff affixed and her own interpretation, she is not entitled to relief here, and the complaint is
How do
insufficient.
you read this contract? You argue in your notice, I think, in your motion, that the plaintiff had 3 business days to cancel the contract from the date that it was entered into. Am I understanding you correctly?
Yes, Your Honor.
Sort of, Your Honor. Sort of. Terry, congratulations. 16 months. Lisi, congratulations. 17 months. Holy cow. Guys, it's going to take 16 plus 17 months to understand this contract. You're going to like this. Guys, thank you for sticking with me so long. I really appreciate it. I really do.
Okay, now wait a sec. You're gonna have to talk. I mean, whoever drafted this contract couldn't have been a lawyer. Could not have been a lawyer. That's why I asked. I didn't want to embarrass you. And probably somebody from the company in the back room was putting together a contract. So I don't even know what this means. I do not even know what this means. I mean, it certainly doesn't mean that she only had until January 23rd to cancel the contract. You got to tell me how I'm supposed to read this. And as the drafter, right, the language, now this is the bad news for you, but I don't know what the good news is for them yet. I'm just telling you how I'm thinking right now, gentlemen. All language here has to be resolved in favor of the buyer as the party that did not draft the contract. I can't understand this contract. I don't know what this means. Maybe one of you can explain it to me. I mean, I sat and read this 3 times, and I still don't know what it means. Buyer may cancel this transaction at any time prior to midnight of the 3rd business day following receipt by seller of your cancellation notice. Now, what in the world does that mean, Mr. Warren? I don't know what that means.
Your Honor, I did not draft this contract.
I know. I asked you that purposely because I didn't want you to have to notify your malpractice carrier. I
appreciate that, Your Honor. Again, taking the contract as a whole, plaintiff's interpretation would permit plaintiff to cancel the contract after complete performance and be entitled to a complete refund. That cannot be what the contract says. It isn't what the contract says. But I think in terms of bad news for me, but good news for the court, is according to plaintiff, plaintiff gave notice on January 29th and again on February 4th. So even if the court was to adopt the 3-day period that plaintiff urges, plaintiff did not give notice twice in 3 days.
Yeah, well, this is just ridiculous language here. I mean, Mr. Badari, I want you to tell me something because I read these I totally disagree with Mr. Warren's interpretation of the contract. But then again, it appears to me, and you can correct me if you think I'm wrong on any of this, sir. I want to hear from you. I really do. The parties entered into a contract on January 20 of 25. Do we all agree with that? That's when Ms. Engel signed and the representative signed for the defendant. Do we all agree that that's when the parties entered into the contract?
I think that's
Yes,
correct, Your Honor.
Okay. And defendant, I think admittedly by all parties, had completed construction and installation of the deck platform and stairs by January the 25th. On anybody's interpretation, she's canceling it at the earliest on January the 29th. And I'm giving credit to, although she didn't comply with the provision in terms of having it written, in writing, your client acknowledged receipt of a voicemail on January 29th from somebody that said, stop the work. The husband passed away, and I'm so sorry for your loss, Ms. Engel. But then on the 31st of January, the defendant sent an email to plaintiff detailing plaintiff's option under the contract and her steps for cancellation. And then on February 4th, she emailed reiterating her contract termination and requesting a refund. And somewhere in there, it looks like on January the 27th, your representatives are trying, or at least they paid on the 27th for the lift. And then there's another email, and I can't make heads or tails out of it when I've got a representative from the defendant communicating with the platform company saying, hey, this is a tragic situation, essentially. Will you refund if we return the platform? And it looks like to me at that point that the company's responding, there's a 25% processing fee. So in other words, we're not giving you back 100% refund, we're giving you 25%. That's the way I'm reading everything so far. If anybody thinks that I've misinterpreted any of the facts, I'd like you to tell me. Mr. Badari?
Your Honor, and that's one of the many additional
Okay.
terms that they
So-
tried to add to an existing contract. But yes, I don't disagree with what Your Honor just highlighted.
Mr. Warren, do you agree with everything I said?
Yes, Your Honor. I think just as an aside, defendant had incurred significant costs in constructing the platform and spent out of pocket. But that's my only
I get it.
clarification.
And the total amount that the plaintiff paid was $9,000, right, Mr. Badari?
Correct.
There's no breakdown in any of these documents, any of these invoices that says, okay, the portion of the contract relating to erection of the item contained in, I believe it's Exhibit 1, is $7,200 or $9,800. There's nothing in there. You just got a total contract price, right, Mr. Warren, of $17,000 and some odd dollars, wasn't it? I'm trying to figure out what the charge would have been for erection of the deck and entranceway, and then how much it would have been for the lift and installation of the lift, purchasing of the lift and installation of the lift. I don't even know what anybody's suing here for. Can you tell me what that answer is, Mr. Badari? Do you know? I mean, they did work. They took a deposit of $9,000. They'd already completed the work. Why don't they get to keep the whole $9,000? There's no counterclaim, right? Mr. Warren?
Not as of today, Your Honor.
To answer your question, Your Honor, you're asking a plaintiff a question that really should have been something the defendant, and it's very, for lack of a better description, an artful contract. But they gave Ms. Engel 3 options, and she opted for the second one, option number 2. It said that the price for what they outlined, and they did not itemize it, and again, that shouldn't be faulted on her, but they had.
You're talking about in their email of February 1, right?
I'm talking about the contract.
Okay, got it.
The
Initial
paginated, it's in defendant's reply, it's their exhibit B, I believe, but in our response, it's exhibit A. But it's page 2 of the contract. And by the way, I don't have a 5th page. I provided the contract that Ms. Engel had been given. But anyway, I think there's enough here to have the terms as she agreed, which was option 2. And if you notice on page 3 of
You're talking
6,
about page 2 of 6 on the exhibit, right?
yes, 2 and 3, where they outlined the various things to be performed and the specific work. But it's not until number 5, project costs, they just grouped together material and labor, $19,700. Number 6, important note, 15% cash discount of $2,955, and they highlighted that on page 1. So the contract price for option 2 is $16,745 because, as Your Honor pointed out, Ms. Engel did pay a $9,000 deposit, which was more than the 50% required to get that discount. So she negotiated a total project cost of $16,745. That's, tacitly acknowledged on page 1 when defendant in their own contract, in big bold letters on the first paragraph to the side of it, note that discounted project costs. So that's the total cost. So in terms of, and I'm sorry I'm taking a long way to answer Your Honor's question.
No, take your time. I'm interested in where you're coming on this.
So the fact that it's within 3 days, 5 days, 10 days of signing the contract, the defendant contemplated that, and right above the signature line on, again, the document says page 6 of 6, but right above where each party signed on January 20, the provision that defendant drafted in his own contract says that the buyer cancels this transaction at any time later than the 3rd business day. Well, she did that. Whether it's 2 days after that 3-day block of time, 10 days, they set, the defendant.
What does that even mean? Can you tell me how to interpret this? Buyer may cancel this transaction at any time prior to midnight of the 3rd business day following receipt by the seller of your cancellation notice. That's like Spanish to me. I don't even know what that means. What does that mean? I can have everything installed and then say, hey, I cancel this, and then I send another cancellation notice within 3 days. I don't understand what this means. That's what I'm trying to get at here. It's the most ridiculous language I might have ever seen in a contract. But the fact is, there's nothing inherent in here, I don't think, that says that somebody that completes the work now has to give a refund and tear everything out. You follow what I'm saying? I mean, they'd already completed the work on the 25th. That's been acknowledged. At minimum, she didn't do anything until the 29th. I'm trying to figure out what that first amount of work was worth, and whether or not the defendant might be entitled to something if they can't return the platform back if they haven't already. I'm assuming. Can you tell me, as an officer of the court, do they still have that platform left?
Your Honor, I don't know the answer to that question, unfortunately.
Well, that's important. That's important. But please, I don't want to get off track here. I'm trying to understand what this language means. And so far, I'm not hearing anything that causes me to think that I'm not reading this incorrectly. I think it's the most terribly worded language that I might have ever seen in a contract. Somebody at the company that is not a lawyer drafted this. What? But go ahead. Go ahead. I'm sorry. I apologize. Anything else?
Just, Your Honor, that plaintiff is stipulating or conceding that the cancellation came within the time frame, whatever, as Your Honor said, the verbiage could have been more thorough. But nevertheless, that 30% is not an arbitrary number. It's the amount that defendant determined in order to protect their small business. They wanted to have a certain amount that was a predetermined cancellation payment. And Ms. Engel complied with their instructions, how to cancel, where to cancel. And by the way, she attempted to send a certified mail, but at some point, they defendant in an email acknowledged their receipt and their cancellation of the contract. They agreed that the contract should be canceled.
Yeah, I know, but
However,
you're not talking about the work on the deck and platform, right? You're talking just on, I mean, the deck in you're just talking about canceling as it relates to installation of the platform lift, right? I mean, the other work was already done. How can you cancel it after it's done? I mean, as
Well,
badly as this is worded.
again, Your Honor, it can be something that as an attractive offer to Ms. Engel. I don't know how
Just so you know. Hey, Steven, missed you. Steven is hilarious, guys. Always makes me laugh. Just so you know, this case is just the precursor to what is coming up next. It's so bad, but this is bad enough. This has this poor judge. His brain is broken and he doesn't know how to move forward.
competitive this particular business is, but in order to have Ms. Engel and her husband agree to go with their company as opposed to others, they provided certain attractive incentives, such as the discount with a cash deposit, such as this provision. Arguably, this is, again, they are the ones who put this language in there. They agreed to it. Both parties signed this. And 30%, it does not say 30% plus other things, or 30% unless we complete 50% of the project. They could have put that in there, but they didn't. And so as Your Honor indicated, any benefit of the doubt should go to the buyer, that the drafter of this, the seller, contemplated all of those scenarios, and this is what they agreed to in writing. And we are simply asking.
Why did you get more than 30% of the contract prices? I mean, 9,000 into 16,745 is more than 30%. I mean, if that was 30% of the contract price, then it should have been somewhere around the neighborhood of about 52 or 3 or 400, right?
Yes. Well,
Right.
again, in our calculations, we indicated that 30% of the $16,745 is
Yeah, but homeowners just sign when they get stuff done for the house and things like that. All the vendors give them paperwork, and they're just, okay, whatever, doesn't matter.
5,023.50, which we said of the 9,000, defendant should be able to retain that. It's the 30% that we are asking to be refunded, which was $3,976.50 of her $9,000 cash deposit. Again, we're just simply asking enforcement of that term that incorporates all these other scenarios Your Honor is contemplating.
Your Honor, if I may,
Sure.
if we look at it's Exhibit 1 to defendant's motion for summary disposition.
Give me
on
one
page-
second.
Yes, yes, Your Honor.
Yep.
It's the second complete paragraph on page 5 of 6. Non-refundable deposit. Buyer shall pay a non-refundable deposit to seller if buyer cancels this transaction at any time later to midnight of the third business days following receipt by seller of your cancellation notice. The non-refundable deposit shall remain the property of the seller. So I agree there is 30% language somewhere else in the contract, but on page 5 of 6 and with the $9,000 figure reduced to writing, the deposit is non-refundable. Again, even if we construe this in against the drafter, against defendant, Ms. Engel did not cancel twice within 3 days. So again, if the court adopts that reading, which it sounds like the court's going to, Ms. Engel did not cancel within the 3-day time frame that she urges the court to adopt. Additionally, as to the cost breakdown in defendant's reply in support of motion for summary disposition, excuse me, at exhibit, I believe it's D, at exhibit D is a breakdown of the costs. So the labor
You
costs.
intend to file a counterclaim?
Your Honor, we've discussed that with my client. We have not filed one as of yet. It's an open discussion with us and our client.
Why? Okay. So what do you think there's a question? Let me, go ahead. And then I'm
So
going to ask you when he's done what the question of fact is here, Mr. Padari. Go ahead, Mr. Warren.
So the total labor costs was $7,313.13. The estimated materials cost was $2,445, and that was for things like the wood and
Where do you have
railing.
that at? Where do you
It's
have that at?
Your Honor, it's an Exhibit D to defendant's reply in support of summary disposition.
Slow down. Let me find it.
Yes, Your Honor.
Exhibit 4, you mean? No. Your
In our-
exhibits were labeled by number, I think, on your motion.
This is in defendant's reply in support, filed on November 10th.
Okay. Okay, go ahead.
So again, it's labor 7,313, materials 2,445, and that doesn't even get us to the equipment purchase of $7,530, which is the actual item from Harmar that
That's
could be
so
returned
cool,
with a
Lisa.
25%
That's so cool.
restocking fee. So defendant is out $17,288.13 already. So
Well, but they're gonna get 75% of that back. Of the platform left.
which would bring the cost
I know.
today to $14,585.63. So plaintiff has defendant partially performed and very nearly completed performance under the contract. Plaintiff paid $9,000 on a $16,745 contract. Defendant has not been benefited here. Defendant is out a significant sum of money. Plaintiff at least got part of the bargain. And to the court's point, there isn't an issue of fact left. The issue is, how do we interpret the contract? And again, if the court adopts plaintiff's proposed interpretation of the contract, plaintiff did not perform the cancellation in the way that she urges the court to adopt. So even if the contract says exactly what she says, she didn't comply with the terms of the contract, which gets us back to who breached first. The answer is plaintiff, and as the breaching party, she's not entitled to the money. So the contract says it's non-refundable. Assuming the court adopts the cancel twice in 3 days formulation, she canceled twice in 4 days. This business about a 30% or a 50%, I understand that the contract says that, but at this point, it's a bit of a distraction considering the performance that has been done and the rest of the contract terms.
I find it interesting, Your Honor, that defense counsel understands the contract says that, but yet he doesn't want Your Honor to enforce the terms of the clear words of the contract. He wants you to introduce parole evidence and modify this contract, which is clear on its face. Again, they may not like the outcome of it, but they're the ones who drafted it. They're the ones who have to abide by it. And that's all we're asking Your Honor to enforce is a contract that they drafted that's clear on its face as to the 30%. I agree, the timing of 3 days, midnight, and all that, when that clock starts to run and when are you late, we are conceding or stipulating that plaintiff did not do it within the 3 days. Therefore, the 30% forfeiture or amount to offset costs and so forth that was built in and predetermined by the drafter of this document. This is what they said they would live by. This is the terms that they created. They don't like it, but they should not have included it, and they should have put in something else, which they are now asking them to introduce and to enforce. Ms. Engel was never provided this itemized breakdown of labor and so forth. This is something that they've created, and it's not dated, or it's not, there's no indication they sent it to Ms. Engel. That's because it never was. And so again, why this additional terms and compensation when it's going outside the 4 square corners of this contract that they drafted, I think is unfair. I mean, they're over. They're saying they're out of pocket $17,000 when they agreed to $16,745. I mean, that's just outrageous. You know, I don't understand that argument, and nor do I understand why they would want to file a counter complaint when they already indicated in an email they would walk away with $9,000 to be satisfied. And again, we're saying that concession on their part really isn't one, because that's not what the contract calls for. And we're simply asking for what I don't mean to be repetitive, but again, it's clear. Defense counsel indicated he understands it's in the contract. So what more needs to be said on that issue? Thank you.
Your Honor, I think it's interesting that we've now gotten to the question of 30%. Plaintiff filed a complaint alleging things like fraud and conversion for treble damages and asking for a $9,000 refund and additional damages. And then defendant filed a motion for summary disposition. And in response, plaintiff suddenly abandons counts 2 through 5, conversion, fraud, and so on. And then says, you know what? It's not 9,000. We'll do 30%. So how do we square this? Because what this looks like to me is that plaintiff received partial performance under the contract, wanted $9,000 back to pay nothing in return for what she received, alleged fraud and statutory conversion for treble damages, and now, after being confronted with the first bit of resistance, is now dropping from 9,000 plus fraud plus all this other stuff down to, you know what, it's just 30% of the contract price is what we're after. So, Your Honor, I think that again, the contract does say 30%, but it says other things too. So I'm not asking the court to ignore the 30% language. I'm asking the court, again, to construe the contract as a whole and not as to the random terms that plaintiff picks out willy-nilly. Plaintiff received the benefit, at least a partial benefit under the contract.
Really,
Defendant is
sir,
out a
calm
lot of
down.
money on this. And again, assuming that the contract permits a cancellation twice within 3 days, plaintiff did not cancel twice within 3 days. She canceled twice within 4 days. So even if the contract says that, and maybe it does, and I think that the court is likely to adopt that interpretation, plaintiff did not cancel twice in 3 days. So all of his business, about 30%, and the rest of it is irrelevant.
Mr. Badari?
I have no idea what, I'm sorry.
No, I don't need any more. If you want to say something, I'll be happy to listen.
Well, there's reasons why, for purposes of streamlining this, Your Honor, we distilled it down to its core undisputed facts. I think based on the undisputed facts that there was a contract, that the provision of 30% says what it speaks for itself. And the contract does contemplate a scenario where cancellation is outside of midnight of 3 days, and that's when the 30% compensation is triggered, 30% of the price. So that was the reason for asking for summary disposition in plaintiff's favor. We ask that you deny summary disposition for defendant and grant it for in favor of plaintiff pursuant to MCR 2.116 I2. That again is just enforcement of a contract that is drafted by the seller and should be honored by the seller.
I don't, I take no great delight in this decision here because I feel extremely awful for Ms. Engel. I really do. I took this stuff home. I read it yesterday. I can't imagine what she's gone through. But here even though this contract is about as poorly worded as I can see, there's no question but the cancellation was not effectuated before the initial work was performed on the decking, and then they had already ordered the platform lift. There still was not cancellation. They did that before any of this was done. In other words, they completed this by the 25th. I believe it was the 27th when they ordered the platform lift. They tried to accommodate from all records. They contacted the seller of the platform lift, asked for some relief. The seller of the platform lift said, we're not going to give you a 100% refund. It would be at least a 25% restocking fee. I just can't under any circumstance find there's a question of fact as to whether or not they were owed the $9,000. I feel awful about this. I truly do, Ms. Engel. I'm going to find there's no genuine issue as to any material fact. I'm going to grant defendant's motion for summary disposition. I'm going to ask you to put in the send me a judgment. Sorry, Mr. Badari. You did a nice job. Good job for you too, Mr. Warren. Thank you both. Good
Buckle
luck,
up,
man.
guys.
Really, I'm sorry about this, and I feel badly for you. Thank you.
Okay.
Thank you, Your Honor.
That was confusing. Broke the judge's brain a
Are
little
we
bit.
ready on Mount?
But the next one is
You're on
crazy.
stuff too. It's 10 o'clock too.
What do we have at 10 o'clock again?
We have GTSC Warehouse and Adkins.
Let's call that
And
one. GTSC
LV.
Warehouse LLC versus Christopher Anthony Adkins, 2404976. Mr. Morton, your name?
Your Honor, for the record, Attorney Ian Morton, P67892, on behalf of the plaintiff GTSC.
Is Mr. Adkins here?
He has not appeared, Your Honor.
All right, what do you guys want on this, council?
Your Honor, the simple breakdown is this. This was a case in which we were granted judgment after a motion for summary hearing, which the defendant did appear back on the 16th of July. He then filed bankruptcy, which stayed the action. And since that point, the bankruptcy has now been dismissed, which we did include documentation to show as such in our motion for filing. We are now asking under motion, and under the court rule under 3105J2, that we be granted execution on our judgment and asking for 28 days from the date of the order from today.
Motion granted. I read your motion. You can prepare the order appropriately. Thank you. Defendant
Thank you, Your Honor.
to appear. Okay, now. Do I have, are you Ms. Parker?
Yeah.
Come on up here. LVNV versus Parker. 2500558. I'm so sorry you had to wait through that whole thing. Ms. Francis, your name?
Good
morning, Your Honor. Nafiat Francis on behalf of plaintiff's attorney of record.
Ma'am, your name? Yeah.
Lori Parker, good morning. Yeah.
Okay, I didn't read this response yet. Did you read her response? She wants me to grant her motions, her objection to garnishment. You want to tell me why, ma'am?
Yes, Your Honor, because this, what they're garnishing from is a workers' comp payment. And from my understanding, according to Michigan law, they're not supposed to garnish workers' comp SSI.
Was this from a bank account or is this from your wages with your employer?
No, so I was injured years back and I've been going through the court case, so I finally got a payment and I deposited. I had to open an account because they said.
What do you have to
Kelly.
say, Ms.
Thank
Francis?
You, thank you.
Judge, she did file a handwritten request. However, she didn't attach any bank statements to prove her arguments. So we would request at least
Sorry, this is just a filler real quick before the main event.
3 months worth of bank statements to show that what she's arguing would be a valid argument.
What I don't like about her, she wants 3 months of bank statements from this lady. This lady doesn't have a bank account. So, I don't know. It's just...
Do you understand that?
Well, this was open specifically for this, and as soon as
Okay, but what they're saying to me is they need to have some documentation and proof. So I can adjourn this and you're to provide them with 1 1/4 of bank statements to verify your argument here.
So the only thing I went to the bank and they gave.
They're gonna have to do better than that. I don't even know what that is, but it's only one sheet of paper.
Well, it's the check that was deposited, it says who it's from, the date that it was deposited, and this is all that I have because I didn't have an account.
You didn't have an account. What do you mean you didn't have an account?
So they sent this in a check and
Let me see what you have there.
and if you, this.
Okay, so this is a check made to her. It looks like it's signed by Sedgwick Chrysler Principal. It says $41,186 and $9,100. 91 over $100. So the check is for $46,186 and 91 cents.
Judge, the only amount the bank withheld is $2,859.63. So I don't really see where those amounts are lining up. We would request the bank statement.
How much is the judgment for?
And no one is listening to her. How can she provide a bank statement when she has no bank account? How? Why does she keep asking for something that's not possible to get? I mean, they can't make her show a bank statement. They can't. There is no bank statement. So how can someone make her show a bank statement?
The judgment is currently for 290178.
2009-0178?
Yes, so I believe they withheld
What?
almost all of the judgment amount.
Well, but that could be with interest or whatever else you guys were claiming, right?
Actually, they did
This
withhold
doesn't appear
the
to me this
exact.
is a big check. It probably was. Are you saying this was some kind of redemption on a case?
Yes.
I mean, it's not a weekly fee here or anything.
Well, that, Your Honor, that is because it took 7 years to get it. That's 1 year worth of wages. It's for medical expenses. I'm still being treated now. I haven't been released to go back to work, and this is supposed to cover me for all of.
You tell me what you want her to have. This looks legitimate, though. I'm gonna hand it back to you. We're gonna make a copy of this, Jennifer, for the file, please. So you're gonna take that down. I'd like to make a cut. You tell me what you want me to have her provide.
Some bank statements, Judge. I don't know if that's the check that went into this account that was garnished or what exactly was in that
Is that the
account
check
that
that
was
went into,
garnished.
listen? Is this the check that went into the account that was garnished?
Yes,
Is there any other, there has to be some other activity in that account.
there's no activity,
You had zero?
zero.
Then get something from the bank, a statement from them telling us that. There are no other transactions other than the deposit of this check.
Yes,
Something on letterhead from the bank, signed by somebody in a position of authority there, okay? We'll adjourn this. But otherwise, I want you to have 1 month of bank statements if I don't get that, you understand?
yeah.
We'll adjourn this until
We could-
December 15th.
You want to do the 1st or the 15th?
Yeah, let's just do the 15th
10 o'clock.
at 10 o'clock, okay?
Okay, Your Honor, thank you.
Thank you very much.
Thank you, Your Honor.
Thanks a lot. Jeez. My favorite case.
Judge, you have a pretrial for UHG versus Delacorte at 10:30. Could we get that? They're both here. If we could get that out of the way, really.
I forgot about this one. This one is just like a minute long. Don't worry.
Quick.
G versus Joshua Delacorte, 2501850. Can you give me a pretrial order, please? Okay, what do we have here? Mr. Delacorte, your name?
Yeah, Joshua Delacorte.
Counsel?
This is attorney Ashley Nelson appearing on behalf of the plaintiff UHG.
What's your P number, please?
It's P84103.
How long you been out? I'm curious.
It's been about 2 years.
So are they're not up to 90 yet, are they? I don't think so. Anyway, okay, what do we have here? Mr. Delacorte,
Hold on, Malta. Wait till Mr. Delacorte leaves. This is gonna get good. I'm telling you.
do you owe this debt or not?
Yeah, yes, I do.
You guys want to try to go into a breakout room and resolve it?
We did, Your Honor, and it looks like this is just going to be a consent judgment, and then the parties will have to work out a payment plan at a later date.
Good. Give me the
once Mr.
consent judgment terms.
So it's going to be the entry of judgment in the amount of $2,130.54 plus costs in the amount of $211.60 and a $75 statutory attorney's fees. And then payment arrangements will have to come later.
All right, let's do this. Let's add this up. You got 2130 plus 211. That's 2341. 2416 plus the cents. It should be 241714, right? Is that right or not? I'm doing that in my head, so I don't know.
You are correct.
Okay, now, Mr. Delacorte, how
Yes.
much do you want to pay per week or per month?
Oh, so I had mentioned with her, I'm actually about to get laid off in about 2 or 3 weeks. But I
Look,
guess
I don't
it's
have a lot of time right now. I got
I know.
a trial ready. I got a big motion that's likely to go on until I'm old. I just want to see if we can't quickly resolve the installment payments terms. Does she have your permission to sign your name to a proposed consent judgment that calls for you to pay 241714?
Yes.
Okay. How much do you propose that you pay per week or per month? I don't want you to go into a big long story or I'm going to just adjourn this. Tell me how much you're proposing.
300 a month.
How much do you make in your employment now?
It fluctuates.
Come on,
Right
tell
around
me,
1,000.
average.
About 1,000.
$1,000 a month is all you're making?
No. I thought you meant a week. So about a month, about fluctuates probably right around 5,000.
Before taxes or after taxes?
Before taxes.
Okay. What's wrong? Is there something wrong with 300 a month? You don't want to take that?
No, that's perfectly fine, Your Honor.
All right. I'll tell you what. You can prepare a separate installment payment order. First of all, she has your permission to sign your name to that proposed consent judgment that calls for you to pay 241714. True?
True.
She's going to prepare a separate installment payment order unless your client wants to agree to that. If they don't, you can make me the bad guy. Put it on a regular order for installment payments. You're going to pay $300 per month beginning December the 10th and the 10th of every month thereafter until paid. Do you understand that?
Yes.
You agree to that? You seem to hesitate.
Oh, when I had mentioned it with her, she was okay with a later date. I was just trying to plan it out for
Time.
after.
What's your later date?
Oh, I'm sorry. Go ahead. Sorry about that.
I'm sorry. No, you tell me what date you want. That's
So we would be back in March. Would that work or no?
Not start paying until March? Is that what you're saying?
Yes.
Is that okay with you? March 1?
yeah. We'll go ahead and do that.
Okay, so March 1, you pay 300 per month, beginning March 1 and the first of every month thereafter until paid. You understand that?
Yes.
All right, just stay up with those or else they can garnish wages.
All right. I appreciate it.
All right, have a great day, you two. You'll submit the orders, right, Ms. Nelson?
Yes, I will, Your Honor.
Go get popcorn,
Thank you
guys.
very much. Have a great day.
Thank you.
Go get some
You as well.
popcorn. Oh,
Come on up here, Ms. Mount. Counsel, if you want to go out in the
there's probably not a chance we're going to finish this. I don't know. I don't think so. I don't think there's a chance. I don't know. But the link is here that you guys can go and finish it if you need to. You'll see what I mean.
hallway, and who is Ms. St. John?
That's me.
If you two, I don't think it's going to resolve, that's fine. I'm just, or is it?
Where she rejected everything.
Well, I'm just telling you, this is going to be a lengthy motion. So if you guys want to go out in the hall or sit here, do whatever you want. That's fine. Thank you. All right, come on up. Concord versus Mount.
Good morning, I'm Craig Dow.
Hang on, let me call the case. 2501975. Thank you. Your appearance.
Good morning, Judge. Craig Dow, P63002 on behalf of plaintiff, the community manager, Ms. Holt Turner's here.
Your name, ma'am?
Karen.
Holt Turner.
Your name?
Karen Hope Turner.
Okay, in the mouth.
I don't even know where to start on this.
Oh, wait. No.
I don't even know where to.
Sugar, the other one's the Karen, I think. Yes, the other one. The one standing back there in the back beside the attorney. She's the Karen. She's very tiny on your screen.
Start on this. Ms. Turner, correct me. If I'm a owner of a co-op or a member of the co-op, I should say, do I have the right to get the meeting minutes?
Only if they pertain to that individual, and anything that pertains to another member will be redacted. That's personal information for them. You
guys don't have anything? You don't have public meeting minutes?
There's two types of.
When we have our
I'm
yearly,
talking about the board meetings.
when we have our annual meeting in June, yes, those go out to the entire membership, and the entire membership is allowed to come to that meeting. That's to speak anything general about the property. If they have any concerns about, rules and stuff, that's our public meeting.
Well, don't you have board minutes of the board
Yes.
meetings?
If a
Is a member entitled to those?
If a member asked to attend a meeting or meet with the board, yes, they're allowed to be in that meeting. We have what's called board briefs that gives the minutes to any member in brief without anything that has to do legally with another member in it. And
I'm going to tell you,
she,
let me just stop everybody here. I'm going to tell everybody my thoughts here. One, let's start with the easy one. You can't submit interrogatories like this, a request to admit like this. You can't do that. I told you you needed a lawyer. I tried to be nice to you. You can't do that. That just borders on harassment and overly burdensome materials. That's all that is. He's right. The court rule leaves you with 20 interrogatories. So to begin with, before I even hear anything, I'm striking your interrogatories and your request to admit from the record. You can prepare those differently. You're limited to 20 interrogatories and 30 requests to admit, period. I'll determine the issue of sanctions later. Now, as to your motion, I don't understand, I am getting sick of this case. I hate to say that. I should never say that. I'm a judge. I should never, ever say that, but I am tired of this case and all the paper I'm getting. You guys are killing trees. But I gotta tell you, I'm sitting here wondering, I ordered your office, your client, to submit all maintenance logs.
We did.
Okay, wait 1 second. I am not, I want to know what all your responses were, because if you think I got nothing better to do, you two on a Sunday and go back and look at every single piece of paper on every exhibit here, I got another thing coming for you. But I want you to tell me what your responses were. I don't know the big thing about the maintenance logs here. I mean, the minutes of the meeting. I don't get why all of this was redacted. I mean, if you're talking about attorney-client privilege, you guys are not talking about, you're not talking about work product or attorney-client privilege in a board meeting, the minutes of the board, they're not in there. If they're in there, here's what I'm trying to tell you, Mr. Gallup. I ordered you to produce all these documents. She's leading to me to believe you did not produce the documents that I ordered in my order of October 14 of 25. If you thought that there were items here that go over broad, covered by attorney-client privilege, covered by the work product doctrine, completely unrelated to anything pertaining to this case, I would have thought you would have filed a motion for a protective order. So, Judge,
We did.
when did you file your motion for protective order before?
Well, it was on November. Let's see.
I know, there's so much paper here. It's
Three, Judge.
okay, so let's take each one of these. You can start out. Did you provide them with the maintenance log and work orders from
Yeah.
July 1 of 25, 15 until the present?
We provided close to over 100 documents.
I didn't ask you to.
No, but I'm gonna go through all. I should send them to you, Judge. We were questioning whether or not we should just send them to the court. We're only required to send to the court items that have to request for admissions, et cetera. We submitted over 100 documents, A through F, based on your order that day. So it's disingenuous of her to say that we only produce redacted board minutes. It is an outright lie.
Okay. Direct your comments to me, not to her.
I'm getting very frustrated with the court.
Well, I mean, I don't blame you. I
360 interrogatories and the request.
I know, she's not doing that. But let's go back. Do you have the maintenance log and work orders from your unit going back to July 1 of 2015?
They provided all they had, Your Honor, is they were provided under, can I send to Jen everything we provided, Your Honor? I had my assistant send it to me this morning.
Jennifer, I don't think I have all this nonsense,
It was
do I?
included in the package, Your Honor. She only included the redacted board minutes, leaving the court leaving all provided.
Yeah.
A through F, there were A through F, because we had 6 or 7 subparts, Your Honor, of the order.
I know.
Ms. Turner worked very diligently before we left the conference to produce these documents. I would be happy to produce to Jennifer for the court, so you can see what we provided today.
Jennifer, I'm gonna have him send
Yes, Judge.
those. Okay, I apologize to you, but I don't know how else to manage this. I'm not doing a very good job on this case. I can tell you that. I give myself an F at best, because this has got to stop. You can't send 25, 35 interrogatories, then 60 to 10 days later. You can't do that. I mean, I get the fact that you're enjoying yourself here.
I thought it closed in the 27th, and that was it. I was trying to,
You what?
I thought that discovery ended on the 27th. I didn't get the order until the day of.
I don't know what to do with you anymore, though. I want to be fair with you. I want you to have an opportunity to be heard, but you're papering me to death. I mean, it's not that complex. It's not that complex. You could have taken depositions. You still can do that. I will still give you an order for allowing you to take depositions. But we're not paying for it. That's up to you. You have to hire court reporters. You have to pay for transcripts, not the court. We're not doing that. We don't have anybody in this fight. You filed a motion and then withdrew it, I'm told, asking the court to provide that, and we're not doing that. But I don't know what else to say. I'm supremely frustrated by this whole crazy Hatfield and McCoy case that I have going on. I really am. So let's just start with this. While he's sending those documents, are you telling me that you don't have the maintenance logs or work orders involving your unit back? Let me finish. Dating back to July 1 of 15.
I do.
Okay. Are you telling me that you don't have any billing or financial records related to charges assessed to you or your unit while you resided there?
Assessed to me.
Well, this was your, I was trying to accommodate when I ordered them to provide all this. You says copy of any billing or financial records related to charges assessed to defendant or her unit while she has resided there. Do you have all that documentation from them?
Yes.
How about communications or emails? You don't even know what I'm going to say yet. Between plaintiff and management referencing issues at defendant's unit. Do you have all those? Which ones don't you have?
I don't have any meetings.
Did you provide that?
Yes, no lie.
Okay. All right, now wait a minute. Come on, stop with the lie stuff, please, Mr. Gallup.
Judge, this is completely untrue. You know, we have to prove ourselves innocent here, Your Honor.
You don't have to do anything. Let me just do my job.
I appreciate it, Judge, but I'm telling you, the frustration level isn't in it.
I get it. Did you provide her with that documentation?
There were emails, Judge. I saw them this morning. We're gonna send over, there was 100 and some pages. We're gonna
I know, you guys are killing me. I mean, I have this is not the only case I have.
It is, but Your
So I'm
Honor,
gonna read 160 of those. How many pages am I reading down the other?
you were under the impression.
Poor Judge Jude. Thank you so much. Thank you. Look at him. Look at him. Oh, this poor judge.
Impression from her pleading that we had only provided redacted board minutes.
Right,
It looked like we gave her nothing.
right.
Completely untrue. She deceived the court. So we're gonna send you what we provided her so that you can get an accurate assessment of what we did provide. Because Ms. Hope worked very hard before the conference to provide this documentation. What we didn't have, we supplemented with 2 affidavits, one from Ms. Turner, one from the board secretary to say why the items that were redacted were in fact redacted, and the absence to anything else that the court may have otherwise required on that October order that you came here with you.
Do you have 100 and some pages of those communications or emails? Did he at least provide you with those?
The only thing
Yes or no?
the only thing I have is the emails that I turned in, it got sent back to me as.
There was an email, at least one or more from Justin Marcus to Justin Marcus and Hope Turner. You remember that one?
Okay, yes, he's very sorry. I'm sorry. I'm so sorry. There was a lot. There was two,
All right,
yes.
what do you miss? What didn't they
Well,
get?
because we.
No, no. Just tell me what you're missing. You're saying they didn't
The
get,
business record of our meeting, that was conducted under Robert's rules.
well, you're asked for communications or emails between plaintiff and management referencing issues at your unit.
And the,
Did they fail to provide any one of those?
no,
Well, then they provided them.
but
Wait a
I
minute,
provided the board minutes that I asked for, all of them. No,
you're not listening. Ma'am, I'm trying to be patient with you. You're making it difficult. You want to play lawyer? It's okay. But you can't come in here and tell me things and expect me not to call you on them if they're not true. So I'm going to read this one more time to you. Annie, why don't you look at the order? Do you have to have the order of October 14th, right? It's my order of October 14th. Jennifer, can you please bring that down here, a copy of that? Here, John, would you do me a favor, please?
Yeah, I can print another one, Judge.
Good. And then just have somebody run it down and give it to Ms. Mount here.
Okay. Your Honor,
Ma'am?
if I can ask Mr. Gallup how, in what manner those documents are coming over so I can watch for them.
Jen, if you could be, Deanna's gonna send it to you, but I'll send you a copy as well. I'll give you email. it's a link. It's a link. It's so large.
Okay, so they're gonna come by email, not
That's all
through
you had to
M-File.
say. Email.
Correct.
You didn't
Ma'am?
need all
Okay.
those words.
I want you to listen. Here's what you asked for. Did I order them to produce
Yes.
any communications or emails between you, between plaintiff and management, referencing issues at defendant's unit? Did you supply her with any interoffice communication between employees of Concord, whether it's Ms. Turner or otherwise, and say maintenance workers or anybody else? Did you supply her with all of those?
Everything we had, we provided, Your Honor, and we provided a link right now, everything we had. If we didn't have it, we had them sign an affidavit as to why. Either we just didn't have it, we couldn't find it. So everything we
Okay.
provided.
Do you have any reason to dispute that? Tell me if you do.
I do because,
You think they're lying under oath, that they're telling me something under oath that could get them in massive trouble?
I just feel like there would be more considering that I have a pattern.
Considering that you have a what?
Well, that they allege that I had a pattern of behavior, I would have discussions or this, all of it's redacted.
How about this? Any reports or documentation relating to mold at your unit, did you receive those? Did you provide those?
You agree with the judge? Yes. Yes, you did get those.
See, when you tell me no, when I find out yes, and we had this hearing, I'm gonna hit you with sanctions, ma'am.
No, but yes, Your Honor, he did, but what I'm asking for is about the mold, the conversations about the mold regarding my,
You asked for reports
yes,
or documentation.
right.
You didn't ask them to reiterate verbal communications that they might have had with you. You asked them
Yeah.
to provide you with reports or documentation. They did do that.
Yeah,
Meeting minutes discussing the defendant's unit. Did you provide them with all of that?
All meeting minutes that were relevant to her unit. Yes, Judge.
Any reason to dispute that?
yeah.
Okay, tell
Well, I dispute that because, like I said, the meeting minutes should have provided more than what I was
I
provided.
don't know why you
It
guys
was
thought to redact all that. You act like you got classified government documents over there.
Judge, with all due respect, this has to do with private member
Those are in the
information we're not going to
bathroom.
give here. We've also offered, Your Honor, we've got copies of the unredacted version that if Your Honor,
I will,
I have them on me, obviously, but if you need them, I've had them provide them to me so you can look them in camera. We're not going to give them to her, personal information about other people. These are executive meeting minutes that it's just as important that her privacy be protected.
okay,
as
okay,
it
good.
would be for
Let me
others.
move on. Any member complaint logs records regarding defendant's unit since she has resided there. Did you give her those?
Everything Hope could find, she has provided her. Correct, Ms. Turner?
Did you receive some of those?
I didn't give any type of disciplinary record.
They didn't say, you didn't say disciplinary. You said any member complaint logs / records regarding defendant's unit since she has resided there. I presume that you're asking for them to supply you with other member of the co-op's complaints, other members of the co-op's complaints about you, loud music, dogs, who cares, right?
Right.
Did they send you what they had?
Yes,
Okay,
they said, yeah,
so you got,
yes.
and then any documentation or communication between board and or management regarding the mailbox being placed in the boardrooms. Did you provide that?
There wasn't anything here.
Did she sign an affidavit to that
That
effect?
was all part of the affidavit. Ms. Turner's here as well today, testify if necessary. There was never a meeting about this. We're not sure where she came up with this.
Ma'am, do you have a basis to believe that there was,
Yes, because there was a
do you have any reason to believe that they're lying if Ms. Turner's telling us in an affidavit that they don't have documentation or communications between the board and or management regarding the mailbox being placed in the boardroom?
Well, yes,
You do?
yes, I do.
Do you have a document that you have?
That's what I'm trying to get is our.
Well, why do you have reason to believe? I have an affidavit apparently telling me that there are no such communications. Why are you so certain that they have them? They can't produce something they don't have. You realize that, right?
I do realize.
Okay, so why are you insisting that they have something?
Well, because the board president at the time called a formal meeting and it was conducted.
I was gonna let that slide. I was just gonna let that slide, but no, I'm not. Judge, you just told a lady to go to her bank and get documents from an account she doesn't even have. You just told her she has to do that. You ordered her to go get something from the bank. She doesn't have an account at the bank. She cashed the check at that bank. She can't produce something she doesn't have. You just said those words to her. Judge.
Did, as of like Robert's rules. And we did that so there could be a formal record.
Oh, so you met with them? You met with them?
Yes, when all this billing was going on.
I'm talking about the boardroom, the mailbox at the boardroom. You met?
That's how that came about in that meeting.
I don't know. Do you know anything about that, Ms. Turner?
Yes, Your Honor. So Ms. Mount requested a meeting with the Board of Directors and she had more than one. The only time the board keeps minutes on a meeting like that with an individual member is if there's action items. There was no action items and nothing voted on in those meetings. Therefore, there is no minutes to verify to her for those meetings.
So you're telling the court, and you have an affidavit to this effect, I assume, from Mr. Gallup's comments here, you don't have any documentation or communications between the board or management regarding any mailbox being placed in the boardrooms?
No, Your Honor. The reason the mailbox was in there is because we had the boardroom built and the board wanted a mailbox outside of the office for them to access. That's why the mailbox was installed.
So this is now that I've gone through this, I don't know what they haven't given you. And you wrote this motion like they hadn't supplied anything. You attached all those board minute meetings, minutes of board meetings that were redacted, I thought, to
If that's all we were given, Your Honor, I would have felt the same way, but you weren't given the full picture.
What am I gonna do with you guys?
First and foremost, Your Honor, we have a motion that we want this harassment to stop. If she wants to fight, that's what we have the courts for. We can have our trial in January. We still want to try and resolve it if we can, but it doesn't seem like she wants to try it. We are abiding by the court rule. You did everything that you could to try and help her with the discovery process. We went through, I took copious notes and drafted the order myself. Ms. Hope spent, I don't even know how many hours. Sure, how much time did you spend on putting together that discovery for Ms. Mel?
2 days.
You know,
And it's like,
and I didn't even give it much thought. I was just trying to help you along here with your discovery, Ms. Mount. I really was, and you want to insist that there's a conspiracy going, and I don't have any evidence to suggest that they did not comply with the court's order. Now, if they start filing false affidavits, I think Mr. Gallup knows me well enough to know, and Mr. Gallup is an officer of the court, so he, I know, would not be doing that. They know I'm not going to take that kindly if I find that out. They know that. He knows that. Anybody who knows me knows that. You gotta stop with the inundating discovery requests and the accusations that everything's a lie here. I'm not saying there aren't credibility issues. You may be right on some of this. But you're getting advice from somebody that maybe shouldn't be giving you advice, or you're going on and pulling out pleadings on computers. You did make it sound like they hadn't complied with the court's order at all. And I was ready to give it to him, to be honest with you. You made it sound like they just had not complied with the court's order. Right? And now as we go through all of this, what's that?
That was not my intent.
What was your intention?
Here to get proper records of meetings that we had. If there was improper, and this is what we're allowed to do. As a member, we're entitled to these records. I don't know why they were here. This is why we're here, is over records.
She specifically signed on her pleading that we had not provided any of the items that you just went through line by line asking her in her business.
See,
So there was some mis-
That is a misrepresentation to the court.
it is. You just acknowledge that they provided you with these.
Okay.
I don't understand the big secret about the board minute meetings though, Mr. Gallup.
It has to do with somebody else in executive session about other people's business when it comes to who's delinquent. If there's other people's units of complaints about that, has nothing to do with her. There's no relevance to her case or anybody else.
All right.
And we're providing our residents the same
Can
protection.
you guys give me unredacted, copies? I will look, I'll do an in-camera inspection. You're coming back here, or you can appear by Zoom. But ma'am, you are dangerously close to having me sanction you. Well, you can't just make accusations and bring motions, and you did say that.
I have reason to believe there are more.
That's okay. I had reason to believe a lot of things in my life that didn't happen that way. It's just the way it is. You have no proof that they're committing a fraud or perjury or anything else. I just don't know how to handle this. I'm not doing a very good job. I probably need to sanction you. I mean, I'm telling you, I'm gonna look at the rest of these documents. Mr. Man, I'm gonna look at these documents that he's providing. I've only got about 250 pages for my reading pleasure here. I'll read those. And, you know, you can, I'll figure out what I'm gonna do. I don't want you to have to keep coming back on this either, counsel. I mean, I really don't.
Well, with all, we're here today, as a result of what we have in front of you, the items that we provided, that she didn't disclose to the court that we had in fact done so. So we will get you unredacted minutes. We ask that that be held, obviously under seal in your office, Your Honor.
Of course.
The last time we had the same issue again, Your Honor, she filed all those 17 motions before, and you warned her before, if she goes off.
I know. Well, I'm not saying I'm not gonna sanction her.
I'd like the court to at least reserve
I am.
sanctions.
I am.
Fees.
She's not a
I am.
See
lawyer.
what we have.
She's
And I'll
pro se.
take these. You're gonna give me your unredacted minutes, and I'll set it for another hearing, and I may very well sanction you, ma'am, so you did make it sound, look at all these documents. If they didn't give you these documents, you tell me. Have you seen?
No, they didn't.
They did? Well, then why'd you make it sound like they did? And this has gotta be, I embellished, it's gotta be 90 or 100 pages here.
I just feel like if there was a lot of issues as stated, there would be record of that.
You got 90 pages.
And there's none that say I'm stalking or all these other.
Well, then they're not,
None.
if they're not providing documents to you and now it comes out that there were documents that they didn't provide to you, I'm not gonna let them use them at trial.
I can tell you as an officer of the court, what you have right there, Your Honor, is exactly what was provided to her. It was a hyperlink that you were provided, and she specifically said, at the pleading, we hadn't provided any of those things. This is exactly what was provided to her.
All right, let's just do this. Jennifer, I don't even know where the register is on that case. Would you just make a
Yes.
note that I'm putting this over? And what day do you guys want to come back here? And you're gonna drop off the unredacted minutes to me. Well, you can send them right to Jennifer on M-File. And make sure you delineate those, that these are for an in-camera inspection. What day are we gonna have them back here, Jen?
Judge, trial is November 27th, so do you want December 15th?
No, trials in January.
No,
Or
try,
January, excuse me, January 27th. Do you want to do December 15th?
no, I wanna do earlier than that. I don't need
Okay.
that one.
We're gonna file that summary disposition motion, Judge.
Yeah. So I'm gonna only give.
December
I can-
1st?
I can read this at Thanksgiving, so give me a date
December
right
1st?
after. What's that?
December 1st?
December 1st would be perfect. Write that on the
10:30?
register, please. At what
Okay,
time?
yeah, no problem. 10:30.
At 10:30.
And that's going to be a continuation of the motions?
Correct.
Is this
Okay.
in person or Zoom?
But the order, I want striking her interrogatories and request to admit, and you are limited in indicating that she can refile them, but you're limited to 20 interrogatories and 30 requests for admissions. And that does not include subparts. You can't have a question and have 22 subparts. You understand?
Yep.
All right,
And you said 30 and then.
correct, max.
Your Honor, we are on some hard deadlines here because,
I'll probably end up adjourning the trial.
because we're gonna want to file this positive motion.
I got it.
So, because we have to file our SD motion by the.
I got it.
So,
I got it.
That's or at least an extension on that.
I will.
So we-
But we'll work it out. You guys come back on December 1. But
Via Zoom or in person.
I don't care.
Because they co-ops and costs, they spent thousands of
I
dollars.
can, that's fine. Zoom's fine. You can appear by Zoom too if you want, or you can come in person. Paul J. Schwab versus,
I'm sorry, you said you were serving the issue of sanctions.
yes, and you can put that right in the order.
Absolutely, I will.
Paul J. Schwab versus Irina.
I thought that went much longer than it did. I thought we would never get to the end of it. Let's see what happens with Jay Schwab.
St. John and Irina St. John versus Paul J. Schwab, 2501729. All right. Names, please.
Good morning, Your Honor. Paul Schwab, improper.
Ma'am, your name.
Good morning, Irina St. John in Frankfurt.
Okay. All right, this is over attorney fees. You filed a counterclaim. He,
Your Honor, if I may address the court, which may expedite matters. The principal case is breach of contract, Paul Schwab versus Marina St. John. The contract has been admitted in answer paragraph 3. In my complaint, I cited the contract. She admits it, so there's no question we have a contract. The only issue in my case in chief is the balance that is unpaid. I pled the pleadings, I pled the fees, and she said something to the effect of, well, they're unreasonable. So we'll litigate that. Her complaint is her counter complaint, as the court may be aware, is alleging everything that I could possibly do evil, including malpractice, legal malpractice. And she's saying, I want all my money back. Well, in our last pretrial conference, Your Honor cautioned her, Ms. St. John, you need an expert witness. And the witness filing deadline was November the 1st. She named her friend, Julia Belova, 30 years ago. That was stricken. She does not have a witness to support her counter complaint. And I have filed a motion waiting until the filing date is over with, giving her plenty of time to file before the date of trial. I have a motion pending to dismiss the counter complaint. She cannot prevail. She does not have an expert witness. She cannot testify as to the standard of care. She cannot testify as to reasonableness. Now, she just the other day filed another answer, and there's not one case cited. So she does not have an expert witness. She cannot prevail on a medical malpractice case.
Legal malpractice.
Legal malpractice.
How are you going to prevail on that, ma'am?
Well, first of all, I would like to say that plaintiff filed his complaint on April 23rd. I filed my counter complaint on June 2nd.
Okay. He's about to rule on this, and then we're about to go into the trial. That's where I stopped. I know what he rules here. And then we're about to go into the trial. That is the part that I don't know if we have time to do, or we're going to go late. So I'm going to keep playing. And hard stop at 7 o'clock, no matter what. Hard stop at 7 o'clock, and we can finish tomorrow. Or we can stop early if it's boring. Or I could just give you the link. I can just give you the link right now. And you guys can. So we'll make some decisions when we get there. We're still 45 minutes away from that time. So let's see what happens.
Plaintiff have plenty of time to file this motion. I'm following your pre-trial order, and it says, which was on July 29, 25, that no motion will be heard on the day of the trial. All motion needs to be filed no later than 20 days prior to the trial date, which plaintiff again goes against your order. Also, plaintiff cite his motion, he cite Michigan Rule MCL 600.2169, and this rule states that qualification of expert witness in action alleging medical malpractice. It doesn't say anything about attorney malpractice. So plaintiff
You can't testify what the standard of care is because you're not an expert.
yes, and
I can't testify as to what the standard of care is for a orthopedic surgeon, a cardiologist. I know nothing about that. I'm not qualified. Neither are you to testify as to what the standard of care is for what he might have done.
No. I watch every single episode of Grey's Anatomy. Don't even tell me I'm not qualified. I am overqualified. overqualified to tell you the standard of care.
But done wrong, and that would subject him to a malpractice claim. That's your counter complaint.
My counter complaint about monetary damage.
I know it is, but how do you have monetary damage unless you have an expert here to say he cost her money because he didn't do something he should have done, because that's the standard of care. That's what a reasonably prudent lawyer would have done under the circumstances that was handling a divorce case. He would have had an appraisal done, or he would have had bank account records subpoenaed, or he would have asked interrogatories concerning the finances. Ma'am,
And I do have this in my brief, overcharging, that he overcharged me. He was charging me prior to signing the contract, which is and it's a big amount. It's all in my brief. That before we signed contract, he started to charge me for some preliminary work. I still was shopping around for the attorney represent me in my divorce case. I have multiple emails that I
okay, but
provided
that
he said that if you decide to hire me on December 13th as your attorney, if you decide to proceed with me. So I didn't hire him as attorney, and he started to charge me thousands of dollars before I even signed a contract. Then he charged me for presence in my house for appraisal service.
look, I'm going to cut this short. I'm not going to strike her counterclaim now, but she's not going to be able to testify as to what the standard of care is with respect to a lawyer in handling of a divorce matter for you or on your behalf. I need to get off this bench for a few minutes, and my staff's entitled to a little break. I will come back in 10 minutes. We'll start the trial at 22, and I will ask you then to give your opening statements, okay? Thank you very much.
I was hoping that wasn't going to happen, and it did happen. I had to wash my hands, though, guys. I can't rush. All right, let's fast forward to when he comes back. I hope he's in a better mood. No, I don't.
One count exhibit A, so maybe at the end of get another count. You don't know Heather's in there, do you?
Speaking of Mel, I'm going to eat Thanksgiving at my niece's house. Is it rude for me to bring a whole bunch of Tupperware with me?
I don't know where she's at. Would you go down there?
I would bring a whole bunch of empty Tupperware bowls with me so that I could just take everything. I'm joking. I'm joking. Now my belly's rumbling because I'm hungry. Thanksgiving.
Hey, do you see Amy down there? Perfect, thanks. Okay,
Judge, she's on her way.
perfect.
I got a live stream on Thanksgiving and then pack it up and get over there and start cooking. Am I making things up, or do turkey prices drop like the week after Thanksgiving? I'm thinking of going and getting another turkey.
Okay. We're back on record, Schwab versus St. John, and of course I have a counterclaim 2501729. Your name?
Paul Schwab in Brookburg.
Irina St. John in Brooklyn.
Okay. Any preliminary matters anybody needs to bring up? Besides what you already did?
No other matters, Sean.
Ma'am, anything you need to bring up? Call you, do you want to give an opening?
In Brookburg.
Okay, sure. You can have a seat, ma'am, and then you'll have the opportunity to give an opening, okay?
Your Honor, as indicated, this is a breach of contract lawsuit. There's no question as to the contract, its existence, its terms have been admitted. Answer number 3 to the complaint admits the contract. Sole issue in the breach of contract is the attorney fees, the reasonableness, the work that was done, and there will be an exhibit marked a narrative detailed billing. It consists of about 6 pages of computerized entries and times and confirmations, very detailed. Testimony will also show in the case that these documents were given to the defendant, Ms. St. John. There was never a complaint of overbilling, nothing. It'll show that Ms. St. John changed attorneys and refused to pay the balance on the final statement. That led to the lawsuit. I anticipate that there will be some attempt to testify as to the counter complaint. And again, if history is any indication, that could be very lengthy as to the plaintiff. I anticipate a motion for directed verdict at the conclusion of the plaintiff proofs. And the court is aware there will be no expert testimony and it just cannot prevail. At the conclusion of the court hearing, I will ask for a judgment of the amount of attorney fees and some of the costs and some of the interest. And that will conclude this matter. I anticipate my case may take 10 minutes.
Thank you.
Thank you, Your Honor.
Ma'am?
First of all, I would like to thank you, the court, for opportunity to represent myself in court. I believe in American transparency and justice of American court. Can I disclose the situation when Mr. Schwab called me during your proceeding and tried to negotiate with me? Can I disclose this information?
Some of the negotiations are really not admissible in the trial.
Yeah, so Mr. Schwab called me and he tried to negotiate with me. Can I disclose what he offered to me?
No, because settlement discussions are not part of the process, that they're not admissible.
Okay,
Okay?
I agree with this. Mr. Schwab just mentioned that he filed this motion to dismiss my counter complaint, and he stated that he 99% sure that you will dismiss this. I don't know why Mr. Schwab is so confident about this. We'll see. I hired Mr. Schwab on December 13, 2024 as an attorney to represent me in my divorce case with my husband, Michael Azell. I signed the contract at that day, at the end of our first meeting. Mr. Schwab overbilled me without my consent for $2,550, charging retroactive charges before I signed my contract. This is included in my counter complaint. He charged me for the days for the December 7th, 9th, 10th, 12th, and 13th before I signed my contract with him. I have exhibits of 2 letters from Mr. Schwab
in which he's saying that if you decide to hire me on December 13, we will sign a contract and I will explain you my attorney fees. According to the Michigan Court's Civil Proceeding Bench book about attorney fees, 8.6, it says that attorney-client relationship must be established by contract before an attorney is entitled to payment for service rendered. And also in the Michigan Rules of Professional Conduct, it says that a lawyer shall not make an agreement for charge or collect an unreasonable fee or unreasonable amount of expenses. I hired Mr. Schwab, experienced attorney, 55 plus years of practice. And I know that it's very unusual for client to file anything against attorney. And I have Exhibit 2, which represent total 13 cases in the last 18 years that Mr. Schwab was suing his clients, and I'm one of them.
Okay, but why is that relevant?
It's relevant because I became a victim of his scheme when he intentionally overcharges his clients, then brings him to the court because he feels very comfortable in a court versus me, just a regular person. I'm a registered nurse. And then he overburdens the court with multiple motions. Like in my case, it's a motion, multiple 4 motions for frivolous pleadings. Whatever I did, following your court rule, I had the right to present a witness. I filed my witness list. I had the right to submit my affirmative defenses. I submit them. So everything was a frivolous pleadings. And he was asking for sanctions multiple times. So that's why this is his pattern. Overbills the client, file frivolous lawsuits for unpaid fees, request multiple sanctions, and enrich himself. So he's suing me for amount of $1,600. And everybody would say, you crazy, go to court and file counter complaint against your attorney, just pay this. And I made my informed decision that I'm not going to pay this because I firmly believe that it was grossly overcharged and overbilled. I presented in my counter complaint section by section that he overbilled me without consent for $2,550. He coerced me for appraisal service of his choice, which was deficient and not admitted, and mediation by a mediator. Versus 1,000, he charged me $6,495, which I paid $3,570 for appraisal service, and all the rest, it was his middleman work and presence at my house for 3.4 hours as, I don't know, bodyguard or who. I don't know how it can be justifiable charge someone attorney fees for being present at appraisal service. It's 2 independent men, they're working independently, they're doing their job, so I cannot justify this. Also, a financial discovery, $4,200, which what Mr. Schwab did, he filed interrogatories, which was grossly inefficient, contained only 13 questions, was very repetitive, so it was actually 4 questions, and they allowed my husband to answer very vague and did not provide any substantial information. And also his unethical behavior, a failure to follow own contract, which according to his contract, I had a due date to pay my balance 14 days. He filed.
Judge Chad doesn't get Thanksgiving. He has to read all those papers from the last case.
A complaint with this honorable court 7 days before the due date. That's all in a contract. Also, he disclosed my personal information with my present attorney, Michigan law. He sent them his statements from his answer to my complaint to Michigan Grievance Attorney Commission. Mr. Schwab knows that I represented myself improper here. And with that case, I don't know why he sent the whole package to my attorney. So he was very surprised too. And also he disclosed some confidential information with my husband when my husband called him. He called me a psychopath. He disclosed some information about my Ukrainian family. And who knows what else he disclosed with him. That could damage my case also. So I'm asking the honorable court and you would be honored to help me, with this case, because I think it's very grossly overbilled and Mr. Schwab did a lot of mistakes. That's why I ask you to reward me $10,000 that I paid for a case that just started in Mr. Schwab's case and dismiss his complaint with prejudice.
Thank you. Call your first witness.
Your Honor, I'll call Rita St. John.
Okay. Ma'am, you can come right up to the witness chair here, okay?
You don't want me. Grab that ramp right there, shouldn't.
Yeah, right up here.
She's toast.
Okay.
She's toast. This is going
Raise
to
your
be a
right hand.
bloodbath.
You solemnly swear or affirm the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, I swear, I do.
Okay. Have a seat, please. You may proceed, Mr. Schwab.
Would you state your name for the record, please?
My name is Irina St. John.
And where do you live?
I live in Grosville, Michigan.
And who do you live with?
I live with my husband, Michael Lizelle, and my daughter, Elizabeth St. John.
Is there a divorce complaint pending with your husband, presently?
At the present moment, my divorce is, we filed the motion for dismissed of the divorce on November 5th.
So he dropped the lawsuit against you. The divorce is over with, right? You're
Yes, we decided to preserve the family.
Do you remember contacting me December the 5th, 2024? Your first call to me?
It's hard to recall, but I recall it, yes.
Yes. You were referred by a mutual friend, weren't you?
We don't have any mutual friends.
Olga? Olga?
That's your former client. She was not my friend, I never met.
She lives in the same apartment complex as your mother and your brother, right?
I never met you in my life.
We spoke that day, didn't we?
We had a conversation on the phone, yes.
You told me that your husband told you he has filed for divorce.
I said that I think my husband filed for divorce.
You were upset, weren't you?
Or wouldn't you be upset?
Okay, just answer his question. Were you upset?
Yes, I was upset. I was shocked.
You didn't have a copy of the complaint, correct?
Of course, because he didn't file at that moment.
And I offered to go down to the Wayne County Court, see if there's a divorce complaint filed, correct?
On December 5th, no, I don't recall that.
Did I go down to see if there was a divorce?
I don't know if you did or not.
Did that work? First telephone call, the visit to the court, the telephone call to you to tell you there's no complaint filed, to talk to you more about your daughter. I didn't charge you for any of that, did I?
I don't know, it states a chart in your, does it say anything?
I'm gonna show you what's been marked as Exhibit 8. John, to introduce this is offered as the billing statements for my work representing, there are two statements, one dated February the 28th, the second April the 16th.
Of 25. Of 25, correct?
April, yeah, 25,
And is that marked plaintiff's one, Amy?
exhibit A.
8?
Exhibit A is an apple.
Good enough. You may approach the witness.
Look at the first 4 entries on that statement. Dated, the entries are dated December the 5th, December the 6th, December the 7th. Any charges for that?
According to your contract, no, it says no charge.
And you continued to talk to me, didn't you, after that? You called me. I called you.
I talked to a few attorneys, yes, I was searching for a
No,
good
I'm
attorney
asking
to
you, me.
represent.
To me,
Yes, I still talk to you.
right, and you
Yes.
talked to other attorneys,
Yes, and I talked to another attorney.
right, and you hired me, didn't you?
I hired you on December 13, 2024, when we signed the contract at the end of our meeting. This is when I made my decision. Yes,
You received a copy of this billing dated February the 28th. You received it by email on February the 28th, didn't you?
I received this, I signed the contract on
No, no,
December
question.
13,
Listen to the
24,
question.
and I received your first invoice on February 28.
That's what he asked.
Yes, 25.
Yeah.
Against your promise, send me a monthly billing every month. Right?
You,
So 3 months later, yes, I received your first invoice, that's correct.
did you object to this billing when you received it?
Can I clarify this?
Yeah.
So when I received this first invoice, we had a very hot, how many hours conversation regarding stagnated discovery? It should be in his bill. 90 minutes, so it's the last page. It will be, oh no, it's 2 here, so it will be end of the first invoice. Page 3, it will be hour and 20 minutes phone conversation on 2/28/25. When I was the first complaining about stagnation of my discovery. So at that point, it was almost 3 months and nothing was done. The answer to my complaint was never filed. It was filed 123 days after the due date. It actually was filed on April 15.
What?
Discovery was not
What was filed on April?
the answer to
Complaint.
complaint, to my husband's complaint. So it was 123 days overdue.
All right, but that's kind of customary in the practice for lawyers to get extensions. So I'm just telling you, you didn't go into default at all, right?
It could go to the.
Yeah, but you didn't go into default.
It didn't.
Okay.
Lucky for me. So the discovery was in stagnation and I was asking Mr. Schwab what we can do. So my husband submitted financial statement, which was lacking all the information, bank accounts, his income. And I asked Mr. Schwab to proceed and force opposing side to provide information, all missing information. Mr. Schwab didn't file a motion to compel. Mr. Schwab didn't file anything with the court to expedite the discovery, to proceed with discovery. I asked him, can we subpoena bank records? Can we do something? He started to impose for me appraisal service. He shifted away from discovery, and that's where I was upset. And this is when I said that.
Okay, so here's what you're doing right now. Just let's slow down. You're engaging in a narrative right now. You'll have a chance to do that later when
Okay.
on cross, so to speak. You're gonna basically cross yourself. You're gonna tell me your side of the story.
Okay.
But right now, I just like you to answer his questions.
Okay.
He sent you this invoice on February 28 of 25, correct?
Yes,
And that's the date of the invoice, correct?
That's when Mr. Schwab sent me his first invoice.
Right, on February 28th of 25, correct?
February 28th.
Okay. And I think his last question was, you didn't object to that invoice at the time, did you? Or did you? I don't know if you did or not.
I was so upset that I did not object to this at that time. That's correct.
Okay. Ask your next question.
And you did not discharge me, did you? You didn't call me up and say, you sent me this billing? Stop work. You didn't do that, did you?
It was my biggest mistake. I didn't. I did not.
So you allowed me to continue working for you, didn't you?
Yes, I did allow it.
Right. Now, do you have any idea of the conversations I was having with your husband's attorney?
I believe that attorney's conversations are not subject to discussions with the clients, right?
Discussed it with me, didn't I? I told you I was talking to his attorney, didn't I?
Yes, you're supposed to talk to attorney. Yes, you did.
And I did. And you are upset by the information that your husband is giving you, correct?
I was upset of lack of the progress in my divorce case.
Right. Now we're into 2 months of your divorce, right? Now we decided, okay, let's do discovery. And I explained discovery to you, didn't I?
At some point you explained the
I gave
discovery.
you the court rule, didn't I?
Can you reference the court rule, please, which you're referring?
The court rule that says I can send him questions, but it can only be a certain number. And you wanted a lot of questions, didn't you?
I wanted as many questions to provide the information that I was needed, his bank account.
That's correct. And we sent those, didn't we?
You sent 13 questions that avoided information about his bank accounts. It was 13 questions primarily about his houses,
I sent you a copy of those questions ahead of time, didn't I?
premarital properties.
I sent those.
Yes,
questions
you
to
did
him,
send.
And you approved them, didn't you?
And you sent them to me and you said, I have to file them with the court as soon as I can. You didn't give me any chance to look, to think about this. So in 2 days, I called you and I said, I don't like the questions. They're very limited and inefficient. And this is when we got in a first fight.
Miss St. John, this was a divorce without children, correct?
Yes,
And I told you that this judge could insist that this entire case be done in 60 days, correct?
don't recall this information.
She may get a trial date, correct?
We didn't have a trial date.
I know, but we could have got, what could we?
So why did it?
The judge didn't set it, but he had the right to do it. I told you that we couldn't delay discovery, correct?
No, you said we need to do appraisals for premarital properties
We've got the appraisal.
and we will send interrogatories.
Okay. You were aware that we're under a very short deadline, 60 days, maybe a little longer, but we could have had a trial date, correct?
Without financial discovery, I don't think we could have a trial date. It would be very unfair to me.
You're not an attorney, are you?
Yes, I had an attorney.
You don't practice in the Wayne County Family Court, do you?
No, I'm a registered nurse at Hermanos Cancer Center.
Okay. We sent out the interrogatories, correct?
You sent interrogatories.
Yes.
I'm on her
You
side.
Yeah.
prepared them and you sent them.
And they were limited in number by the court rule.
Till 20 and you sent 13.
Yeah, but there were subsections, correct?
How many subsections was there?
I'm just asking you, were there subsections?
I don't know. You prepared them, you should know.
Okay. All right. So they were fine. Then your attorney discharged his attorney, didn't he?
Wait a minute, I think you misspoke. You mean her estranged husband? You said your attorney discharged his attorney.
Yes, I'm sorry. Your husband, Michael Lozelle, fired his attorney, didn't he?
He did.
Yes, fired a new attorney.
Irrelevant.
He did.
Correct. And we were waiting for the substitution of attorneys, weren't we?
How long we was waiting for?
We were waiting, right?
How long we was waiting for? 7 days?
Okay, but you just have to answer his question, okay? Were you waiting for the substitution of attorneys? Did you have that discussion with counsel?
It was a substitution of attorney very shortly. I don't know what we was waiting. He fired attorney in 1 day and he hired attorney in the same day. So it was very fast. I didn't even notice that.
Miss St. John, you were in a relationship with your partner, Michael Lozelle, for numerous years, right? Well, since like 2009? When did you start living with him?
2014.
2014. And when did you marry?
2020.
So you were living with him for 6 years, correct?
Yes.
And your husband had what, 6 or 8 rental homes in Woodhaven, Trenton, Southgate, correct?
He has a few rentals in Southgate and Wanda.
Those were in his name alone, weren't they?
Yes.
Not your name, you were on. The only thing that you were on was the marital home in Roseville. That's your name. You co-own the marital home.
Yes, you know that.
Yeah.
I know, but he's asking you questions. Now, don't be so combative now, okay? Go ahead.
And I explained to you marital property and non-marital property, didn't I?
Yes, you explained this to me.
And I explained to you, much to your disdain or your concern, that in most divorces, when non-marital property, when your husband's separate property is kept separate, it's not subject to a settlement in the divorce. Remember? I explained that to you, didn't I?
Okay, you did.
Yes. And you were upset by that, weren't you?
I don't recall myself upset about this. I was upset about the divorce, not about separate
Oh,
property.
you weren't concerned about money? You wanted the best settlement possible, didn't you?
You offered me the best settlement possible.
They sure did. Okay, I explained to you a theory that we could pursue would be business law partnership, and we could go after the appreciation. Not the value of the house, but how much they appreciated during your relationship, correct?
Correct.
Right. And we hired an appraiser, didn't we?
Yes, you stated that I can get appreciation from 2014 to 2020, and you suggested to hire an appraisal.
Yes, to establish how much the house is appreciated from 2014 to the date of filing. And we hired a licensed appraiser. An appraiser that is licensed by the state of Michigan.
You suggested your appraisal that the only will be reliable in a court.
No, I recommended an appraiser that I trust.
It's called a reference.
And he came to your house in Roseville, and he personally went to the 5 houses, correct?
Yes, he did his job.
And was your husband happy about that appraisal?
He allowed them to do, he agreed to appraisals.
Was he pleasant?
He agreed to appraisals. I cannot judge my husband's attitude towards that. He agreed, he went with them, he opened the doors for each house.
Did he allow you to go with us?
No, but I was not necessary to be there in his opinion.
Did you have any guarantee from your husband that he would allow that appraiser into these rental homes?
There is always a possibility that my husband will change his mind.
Right. And I explained that to you, didn't I?
That my husband will change his mind.
Yes.
I don't remember you explaining me this, but okay.
I appeared at your house at Rosio. The appraiser was there, you were standing outside the front door, and your husband was standing outside the front door. Remember that
It
morning?
was inside our house, not outside the front
When I
door.
appeared,
It was allowed by me in my house, and he was inside the house, so it's incorrect.
Did you have any objection to me being there that morning? Did you say, go home, Paul?
I had objection prior to you to come into my house. But you came anyway. Because you love the Gruzil and you wanted the Gruzil.
And I went to the 6 rental homes with your husband and the appraiser, correct?
I don't know what you did after you leave the house. I didn't go with you.
Then you discharged me. Said, stop work.
I discharged you on April 16, 2025.
I email, send me an email at 10 o'clock at night or something. Stop work.
No, not 10 o'clock after our conversation.
You sent me an email. Stop work.
Zach,
And did I respect your instruction? Did I stop work?
you ignored my email. I have to send you a second email and you responded to my second email.
And I responded by copying my entire file, correct?
You responded to me, you said, I received your email, I will stop working for you. But it was answered on my second email.
And I
Not my
gave
first email.
and copied my entire file, correct?
You didn't give me anything.
I sent it to your attorney, didn't I? Lisa Efros.
Lisa Efros, not my attorney. Lisa Efros is my husband's attorney.
I'm sorry, your new attorney.
Who was your new attorney, ma'am?
Michigan law, Derek Jacks.
Derek Jacks?
Yes. You sent the whole file to my address in Grosville, and on the top of that file was your complaint for this court.
Yeah, April 17th.
You didn't give it to me personally. You didn't send this to my attorney. You sent this to me by mail.
You haven't paid the balance of the fees on that final statement, have you?
That additional fee that you imposed, no, I did not.
And I've asked you to pay it, haven't you? Haven't I?
You asked through the complaint with this honorable court. And today we're here on a trial.
And I served you with it, correct?
You served me with a complaint, yes.
So you know that I've asked you to pay the money.
And I answered to your complaint and I filed counter complaint for monetary damage.
I have no further questions on this, Sharon.
Okay, now you can tell me whatever you'd like to say as long as it's relevant.
I have my little paper.
I'm sorry, what did you ask?
Can I have my paper?
Well, you can't just read off of a piece.
No, I will not read.
Okay, what do you need the paper for then?
Well, Mr. Schwab has his papers and he was, and I
He
have,
wasn't testifying. What,
Sure, and may I ask for clarification?
Good.
I just expected to give a few statements of sort of self-testimony, and then I was gonna rest. Then I would assume that if Miss St. John has a case, she will testify.
Yeah,
Is
you
that-
want to do it that way? I don't care. You were called. If you had a lawyer, your lawyer could ask you questions right now. Since your lawyer can't ask you questions, you can tell me whatever you'd like to say with respect to anything that's any way remotely related to what he's asked you. If you want, and I could care less which way we do it, he can testify now. And then you can come back up and tell me your story. Do you want to do it that way or do you want to do it this way?
I want to ask Mr. Schwab a few questions.
Well, so how about so are you good with him testifying and then you cross-examining him?
Whatever will be convenient.
Well, I want you to decide. If you want to tell me your side now, you can, and then he can testify and you can examine him, or
My story and then I ask him a few questions, right? That's what you're saying me? No,
either way, you can either ask him questions after he testifies and then come back up and tell me your story, or you can tell me your story now and then ask him questions after he testifies, whatever you'd like.
I will tell my story.
If I may make a suggestion.
Sure.
If I testify now and rest, then Miss St. John can call me as a witness in her counter complaint, and she can testify it. So it's really two separate lawsuits.
Right.
But this way, she will testify, her attorney, if she had an attorney, would have asked her questions about that. So I think it'd be, for the sake of the record,
And expediting it.
allow me to just testify and rest, and then she could call.
It's fine with me, whatever you guys want to do. Either way, you're going to get to tell me your story and you're going to get the question here.
Have my answer to what Mr. Schwab just was asking me. Can I do that? And then I.
Yes, she can do that. You can do that. So I'm going to let her testify and then she'll sit down. You can call yourself. She can examine you and we'll go from there.
As long as she understands that she can only comment or explain what I cover with her.
Well, I mean, she's got some leeway. This is cross. I mean, go ahead, ma'am. Tell me what you.
Let's make it simple. So I hired Mr. Schwab on December 13, 2024. The conversations on the phone that we had prior, I had multiple conversations with different attorney because I was never filed for divorce in America. I didn't know what is a proceeding, so I wanted to know how everything goes. So I was talking to few attorneys on a phone along with Mr. Schwab. And I was weighing my options. Some attorneys will be aggressive, some will tell you, oh, here is my strategies. Somebody will, have a jokes with you, and you thinking and you looking. So prior to December 13, I was talking to few attorneys and looking for the best option for me. Mr. Schwab never told me that he will charge me for any of this conversation, not just for the first one, for any of them. He didn't disclose his attorney fee. He did not explain his attorney fee. He was nice to me. He offered, he said, oh, you don't know if your husband filed for complaint. I will be in a court. I can look up. Okay, you can look up, So when I made my choice, I'm like, okay, I will hire Mr. Schwab. I came to his office on December 13, 2024, and still I was thinking how the conversation will go, what he will say. The first thing that when I came to his office, I opened my mouth, he shut my mouth. He was talking for straight 1 hour. Mr. Schwab likes his voice.
It's 7:00. Let's see how much longer they're in there for. Way too long. I cannot do another hour. We have another hour of this to go. So we're going to have to pick this up tomorrow. I know I gave you the link, but I really want to see the end of this very badly. So we're going to finish this tomorrow. We already went over time anyway. We can't. I don't have another hour in my day. OJ would get pushed back so far. So we have to stop now. We have to. I got to get my daughter to work in a few minutes, so I need to set up at OJ. Yep, tomorrow we will finish this great docket. Josh, thank you. Josh, you don't even know. I spent hours last night looking for content and came up with like nothing. Like it was all just so boring. And I didn't know what I was going to do today. This morning when I woke up and well, no, I was still at 3 a.m. I was still looking. And I was like, oh, I thought I was just going to play one of my old live streams. I'll just do that. Or Judge Sala. And then I remembered you sent me that text a couple days ago saying, if you need content this week because of, I don't know, if I was working a double or everything is burning down, you're like, yeah, this is pretty good. And boom, it wasn't pretty good. It was awesome. This was awesome tonight. I loved this. I loved it. I watched it twice. So, all right, guys. I'm going to set up OJ. Have a great day. Thank you so much for coming out. For 16 months, for 17 months, for 18 months. Michael, I love you. I hope you're feeling okay, Michael. But Michael's here. We got to go. Even Michael can't make me keep going because I can't. It's 7:01 now. I will see you all in OJ. Behave, guys, okay?
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. and see for